and member from Surrey Panorama.
Thank you, Madam Speaker. I will just pick up a little bit before I left off to keep a continuity here and give it a third try at this. Madam Speaker, I understand the importance of judicial independence. I understand the sensitivity of communications between the judiciary and the executive. But this provision is extraordinarily broad. It covers communications about proposed policies, proposed programs, proposed enactments. It covers communications made on behalf of a judicial officer, which could include staff, clerks, or anyone claiming to speak for a member of the judiciary. And it is drafted as an absolute discretion of the head of the public body, with no requirement to demonstrate harm, no balancing test, and no obligation to disclose after any passage of time. This is a new exemption carved out of whole cloth, and it should trouble anyone who believes the public has a right to understand how its laws and policies are shaped. I also want to touch on Clause 15, which is amending Section 56. Currently, there's a hard limit on inquiries into review, 90 days. This bill allows the Commissioner to specify a later date. So we have a system where the government delays the initial response. Then, if you're lucky enough to get a review, the Commissioner can now delay the review indefinitely. Specify a later date. What date? Next year? Next election cycle? Justice delayed is justice denied. Information delayed is democracy denied. Madam Speaker, why are they doing this? Why, in 2026, are we moving backward on transparency? It's because this NDP government has realized that their policies cannot withstand scrutiny. They don't want you to see the internal memos on why the decriminalization of hard drugs failed so spectacularly. They don't want you to see the real data on their housing starts that are plummeting, despite their announcements. They don't want you to see the correspondence regarding the cost overruns on the Surrey-Langley SkyTrain or the North Shore wastewater treatment plant. They don't want you to see the deals regarding Indigenous land claims that are being cut without public consultation. If they were proud of their record, they would open the filing cabinets. They would say, look at what we did. But they're not proud. They're afraid. They're afraid of the voters. When the Premier took office, he promised a different way of doing things. But the only thing that is different is the creativity they apply to censorship. It's the same old NDP. I want to return to that phrase in Clause 13, unreasonably interfere with the operations of government. Let's be clear, the Freedom of Information Act is an interference. That's its purpose. It was designed to interfere with the natural tendency of power to protect itself. When the government spends $100 million on a computer system that doesn't work, an FOI request interferes with their attempt to cover it up. When the Minister of Health fails to hire the doctors promised, an FOI interferes with the ability to spin the numbers. When the Minister of Reconciliation says he knew nothing of granting Indigenous title over most of the LMD, when it is obvious to everyone this government knew exactly what was going on. This bill allows them to hide the briefings that they received under the premise that it would interfere with this government's secret negotiations. By making interference a grounds for rejection, the NDP is essentially saying, you can only have the information if it doesn't bother us. You can only have the information if it doesn't make our jobs harder. That's not how democracy works. The government works for the people. The records belong to the people. The people have a right to be a nuisance. The people have a right to be repetitious if they aren't getting the truth. I want to highlight the transition clauses again, specifically Clause 26. It says the new stricter detail requirements in Clause 2, the reasonable time excuse, do not apply to retroactive requests. However, Clause 28 says the malicious and interference excuses do apply retroactively. Look at how carefully this is crafted. It cherry-picked which rules apply backward to maximize the ability to kill existing requests. This is weaponizing the transition. It is clearing the decks. Furthermore, this deserves special attention, Madam Speaker. Clause 28 makes the expanded grounds for disregarding a request retroactive. The transitional provision states that Section 43, as amended by this bill, applies to requests received before, on, or after the date this section comes into force. Retroactive requests that have already been filed, requests from journalists, from opposition researchers, from concerned citizens, can now be subjected to these new, broader, undefined grounds for dismissal. The government can reach back in time and make inconvenient questions disappear. If that does not chill the blood of every person who values democracy, accountability, I do not know what will. Madam Speaker, this bill is an admission of failure. Only a government that has lost control of the narrative, only a government that has lost the trust of the people, feels the need to hide to this extent. The Conservative Caucus believes in an open, transparent, and accountable government. We believe that if you spend the public's money, the public has a right to see the receipts. We believe that if you make decisions about public land, the public has a right to see the negotiations. This bill moves us in the opposite direction. It takes the free out of freedom of information by adding fees. It takes the information out by creating broad, undefined categories for rejection. It empowers the government to label its critics as malicious. It empowers the bureaucracy to hide behind unreasonable interference. Madam Speaker, when you step back and look at this bill as a whole, not clause by clause, but as a complete picture, the pattern is unmistakable. This is not a transparency bill. This is a secrecy bill. Clause 2 makes it easier to reject requests. Clause 3 weakens the duty to respond. Clause 7 creates new exemptions from disclosure. Clause 13 massively expands the grounds on which requests can be ignored entirely. Clause 21 introduces fees for proactive disclosures. And Clause 28 makes the expanded grounds retroactive. This is not a bill to modernize the FOI Act. It's a freedom of information. It is a bill to immunize the NDP from accountability. We've seen the scandals. We've seen the mismanagement. And now we see the cover-up. And I want to bring up, today alone, we saw the power of a freedom of information request. When the Premier, actually, let me back up, because I was questioning how a freedom of information request came in so quickly around the issues of the Musqueam land deal yesterday. And today we find out it was from a previous issue. I mean, I'm thankful that the NDP agrees that they did know about the Musqueam land deal now through that Freedom of Information Act request. But again, if we'd been relying on the later information request, we wouldn't be expecting to see it for months from now. We are now just getting a Freedom of Information request from last year. So I urge every member of this House who believes in the fundamental democratic principle of transparency to reject this bill. Do not give this secretive government more shadows to hide in. Madam Speaker, the people of British Columbia deserve the truth. Bill 9 is designed to ensure they never get it. I thank you.